Hi, my name's Scott Stoller with Solid Scott Real Estate. I specifically help people who have inherited property and help them feel less overwhelmed through the process. And I have Anna Howard with me. She is an amazing estate planning attorney here in San Diego County and super helpful. And I had this situation come across my desk recently, and I thought that it would be better to get your input on it. These two siblings, they inherited a home, and when their parents passed away, one of the brothers was living at the home. The other brother, he had already moved out. He's been paying rent on his place, and he's getting a little frustrated because although they've decided that at some point they're going to sell the property, every time the little brother who's still living there has a problem, like the refrigerator breaks, the toilet gets clogged, something like that, he's calling up his brother and saying, hey, who do we call and who pays for this? You got money, right? Meanwhile, little brother's not paying the bills or paying rent or anything like that. So what could a situation be for this issue?
Sometimes, rather than talking in abstract, it helps to give names. So let's just name these guys. Let's call the one who moved out Mo. Mo's older. Mo perhaps was the executor of mom and dad's will that said the boys get the house. Let's call the one who's inside the house Ian, just for ease, the little one that's forgetting to set aside money for the refrigerator. Mo and Ian really need to administer their parents' estate plan, whether that estate plan was a will or a trust. When there's death and everything gets inherited, somebody is facilitating that, and we call it administration. And part of that administration process is meant to put good paperwork together to clarify these things so they don't have to address it as situations arrive. The preemptive way to get on top of like Ian running up bills and then Mo standing there outside of the house, having moved away, saying like, eventually I want my cut, is to have them both sign off on a co-owner occupation agreement. Perhaps now that they've received their inheritance, Ian and Mo are both on title to the house. We can get into a separate conversation about whether they hold it as joint tenants or tenants in common, but let's just pretend both are titled on house, but only one lives there. It's more robust than it's not a roommate agreement. It's only Ian who's occupying, but it stands to reason that the person who has exclusive use of the house should simultaneously be responsible for some of the normal upkeep costs. Because if that house, let's say it's worth $3,000 a month in rent, Ian is supposed to be giving Mo $1,500 every month for the exclusive use of the house. If both guys put a tenant in the house, they would be splitting the $3K that tenant is giving them, right?
Yeah.
But on the other hand, in lieu of Ian paying Mo $1,500 every month, Ian could use that $1,500 to make sure that it's well kept, to make sure that he's in step with all the HOA rules and regulations, to make sure that there's a landscaper, to have it ready to pay for the property tax. And they can put the particulars into that co-owner occupation agreement, particulars that include at some point a termination. Because if their relationship sours and Mo wants his half, Mo's not going to move in. He's probably just going to force the house to be put on the market. Can he do that without Ian's participation? Yeah, it's called a partition. The sad way it's accomplished is if they're really not cooperative anymore, Mo's going to petition a judge, and a judge will say, of course, what am I going to do? Like chainsaw the house in half to give each of you half of the house? No, unless it's like a duplex. That's possible. So chances are the partition in court will succeed. The court can say, Mo, you unilaterally can put the house up for sale even without Ian's participation. You'll have to evict him. That can take a year. But ultimately, Mo, when the house does sell, you do need to give Ian his half back, less your costs and the cost of all this. Generally, that's how it's meant to go through. Now, wouldn't it be great if they had preemptively had that discussion? And in the co-owner occupation agreement, they say, if one of us tires of this arrangement and wants to buy the other out, they've got 6 months to put brother on notice to buy brother out. Otherwise, we mutually agree that in lieu of spending on an eviction, the other person will move out. Ian gets $5,000 for being cooperative and not making a share of change locks on him. And then we will mutually agree to select Scott to put the house up for sale.
So it's essentially like two brothers are coming up with a lease agreement, in other words, correct?
Yeah. I've helped people write these, and we've used a typical lease agreement as a jumping off point for what things they want to include and exclude, because lease agreements have a lot of disclosures. Is there lead paint? Like, what's going on? Probably that would be overkill for Ian and Mo. They both are.
Especially in a home that you grew up in or you
Yeah.
lived in with your parents for, I mean, even a few years, you would have some understanding of what the property's condition was.
Yeah. But let's zoom back for a second. I know this wasn't part of the prompt, but it just makes me curious. If I were on the phone with either brother, I would say, well, what did the trust say, or what did the will say? Did it just say that the two of you are meant to own it? Let's pretend that Mo was the executor. Let's say it was done via a will, which meant there was a probate, but somebody was meant to carry out these terms, and that executor or that successor trustee really has an obligation to close out the trust and distribute to both of them, or to cover all of these loose ends. So I think the question becomes, was Mo derelict in his obligations to execute this will in a proper way? If you're going to put two adult children on title, it really needs to be crystal clear. If one of them is also going to live there, are they going to pay rent to the other? Are they going to cover these expenses? So why wasn't this done sooner? As much as Mo is aggrieved by Ian saying, like, where's money for the refrigerator? Mo, in my hypothetical, needs to take a mirror to his face and realize, oh gosh, I really was supposed to do this, right? When I was the one that put both of our names on title without any sort of accompanying document. And if it's still stuck in mom and dad's trust, see, a lot of people think that they've inherited their parents' trust, but they never fixed title. The title to the house still says deceased mom, deceased dad's trust. Trusts have to close at some point. It's called a rule against perpetuities. Speaks to the notion that you can't just have land forever held in one family. That's like a feudal state. I think of Downton Abbey whenever I think about that, like follows the first male child. A trust has to conclude and then go to new owners. And so part of that trust administration ought to have been putting together the rules of engagement for these guys. So it could also be that Ian's only allowed to live there as he's putting up money to eventually buy out Mo. And if after 3 years he can't do it, maybe his half, all that money that he owed Mo is offset. So his 50% is diminished a bit. He's only going to get 40, Mo's going to get 60 when they put the house up for sale to offset the rent that wasn't getting paid.
It makes a lot of sense. So it sounds like a partition action. That's similar to the same action where they take in a divorce, let's say, where if one party wants to sell a home and the other party says, no way, I'm living here, this is my home, we're fighting till the end of it for you. That's a similar thing here. So, I mean, that sounds like that could actually be pretty aggressive and really shake up the relationship in some degrees, especially if people aren't expecting it. So maybe this owner occupation agreement's actually probably the best first step. What would you say would be 4 things that these brothers should absolutely do, whether it's in probate or they have a trust?
What should they do? Before things escalate to filing in court, have a family meeting. It's a good parallel that you draw to a divorce. Ideally, when people are facing going to the family courthouse and leaving it all to a judge to decide, they try to negotiate some sort of mutual agreement. We call this settlement, or some people would call it going to a mediator. And in a similar vein, probate would love to see families settle this privately. So if this house that was left by the deceased parents to the adult kids was in a trust, there is no need to go to court unless there's like ire and discord and somebody's contesting. And it's one of the reasons, although I've done family law in my decade of being a solo practitioner, I don't love it. I think I'm happier to work with a harmonious family, not people at their wits end in a nasty, protracted divorce. I'd rather see 2 adult kids who they're not in a marriage together, but they still grew up together, to preserve that sibling bond by helping them hammer out some real life parameters about this one asset, just the house, and how they're both going to ultimately get half of it one way or another is really joyous. So I would have them meet with a couple of attorneys, but the attorney would be assigned to administer the trust or to help the executor carry out the terms of the will, administer the will. So the legal consultation that they need, I would couch as administrative. So helping that person who is left in charge, and maybe they both were, a lot of parents, I don't think it's wise for a lot of parents, but both kids on as a simultaneous decision maker, which probably led to this sort of mess.
Yeah.
But ideally, the way to clean it up is to have the executor or the trustee be given further advice via administration. So some attorney is hand holding, probably charging an hourly rate to tee things up a little better, to create more of a clean, completed distribution.
And just to be clear, that doesn't have to be the same law office that originally drafted the trust, correct?
Yeah, well said. Ian and Mo, in my hypothetical, may not want to work with that attorney. Maybe the parents wrote their plan back in the Bay Area, but Ian and Mo are in San Diego, and that's really arduous to have Zoom calls with counsel in another part of the state. Or the attorney who wrote it for mom and dad died. Now, I've also been in the honored position, to help the adult kids of one of my deceased clients, but the loyalty of any firm that touches the case is to the wishes of the deceased parents, not to what serves the brothers. And as long as people understand, hey, Anna, you're guiding us to be true to these documents, not to carve out whatever angle is best for me as an individual. So I have my clients sign off on that. Then my duty is to the set of documents, and then I can help them administer the trust.
Awesome. That's a great way to put it, because so many people, especially when there's a trust, think I can do whatever I want and not realize that there's actually this document instructing how someone's final wishes were to be laid out and how their legacy is meant to be handled and passed off in a caring manner to the next generation. So it sounds like there's 4 things really that Mo and Ian should do. Number 1, they should reach out to an attorney like yourself, Anna Howard, some help with the administration, at least to understand what the responsibilities of the successor trustee are in this. And if they need to go down doing any co-occupation agreements or owner occupation agreements, that would really be a helpful start, because then they could get it clean and make sure that everyone is covered. And it's not saying that one's going after the other, it's just so that the playing field's level, everyone's in perfect communication and totally understanding what they need to do. And I'd say number 3, document everything, every expense, whether it's Ian or Mo paying for that expense. They need to keep receipts and have that filed ideally in one place. If they're on speaking terms. If they're not, then keep it in a safe place for themselves. And worst comes to worst, if one of them, says, "Hey, well, I'm just going to live here forever and I'm good doing this," and the other says, "No, it's time to get the ball rolling down the hill," then maybe at that point, if they can't come to an agreement, it's time to initiate that partition action.
Agreed. And I would point out one other avenue. Let's create a scenario where Ian, the one who's inside, the younger brother, was maybe a bit favored by the mom and dad. And so Ian's actually the one who was the executor or the trustee. And Mo is just ticked off. He's moved away. He feels like Ian hasn't shared the trust with him. He's really in the dark and he's very frustrated. Mo could hire his own attorney, and that, it wouldn't be called trust administration. It would be direct representation of Mo in Mo's capacity as a beneficiary. And Mo's attorney could serve letters to Ian saying, "Hey, Ian, you need to disclose now what's going on with the trust. You need to show your bookkeeping and show your records and explain how you are adhering to all the rules that you're meant to follow as the executor or the trustee." That's getting closer to a contest case, like we need to go to trial because Ian's behaved badly and he's stealing money and he's not doing what the documents told him to do. So the harmonious way is just to get an attorney to help both the entire family administer the trust. But if that's really not initiated by the decision maker, then the other route is the interested party, i.e. Mo, the beneficiary, can scrutinize what's going on with the person who's supposed to be transparent.
Awesome. Thank you for that, Anna. And one last thing before we wrap up right here. If someone needs to get a hold of you and ask you a question directly, what's the best way for them to reach you?
Well, we do text or phone calls, certainly email. Email is actually the quickest way to reach me directly because I have staff that answer the calls and answer the incoming text messages. But shameless plug, my email is info@achowardlaw.com. realtor.com, and my phone number for texting or calls. Free 25-minute consultations to determine if I'm the right fit, to determine if it's a case that is in my repertoire. And I'm always happy to give that free consultation, because if I'm not the right fit, ideally, fingers crossed, I can give the family some free resources, some other directions and avenues to pursue. I just yesterday sent a family links to Adult Protective Services, the Skilled Nursing Home Ombudsman, free information the family can walk away with if the attorney's not the right fit. We're pretty
That's
dialed in
awesome. And
resources. Yeah. Thanks.
that's huge to understand. Thank you for sharing that.